The farm had existed long before anyone thought homeowners association was a good idea. Long before neat rows of identical houses appeared on glossy brochures promising luxury living and strict rules. Those 3,500 acres were older than the roads around them, older than the zoning maps, older than the people who now believed they could control it with paperwork and signatures. I inherited the land quietly. No announcement. No celebration. Just a thick folder of documents, a will signed decades ago, and a title deed that traced ownership back generations. The farm wasn't just land, it was history. Rolling fields that stretched to the tree line, creeks that cut naturally through the soil, and a farmhouse that had weathered storms no HOA board member could imagine. At first, nothing felt wrong. Property taxes were paid. Boundaries were clear. The farm wasn't part of any development, wasn't governed by any association, and legally stood outside the reach of suburban regulations. It bordered an HOA-controlled neighborhood, but it had never been part of it. That distinction mattered. Or at least, it was supposed to. The first warning sign came subtly. Surveyors appeared near the edge of the property without permission. Stakes showed up where none had existed before. Bright flags marked sections of land that were very clearly not for sale. When county records were checked, everything still showed the farm under my name. Clean. Untouched. Secure. Behind the scenes, though, something had already started moving. The HOA bordering the farm had been struggling. Property values were stagnant. Expansion plans had been denied. Developers wanted more land, and the farm represented opportunity, open, valuable, and inconveniently owned by someone who didn't attend HOA meetings or care about their future cul-de-sacs. What followed wasn't confrontation. It was assumption. Annexed land. Deeds were filed that mimicked legitimate county formatting, buried among thousands of real records. Developers were shown contracts claiming authority the HOA never legally possessed. And then, without my knowledge, the unthinkable happened. The farm was sold. Not part of it. Not an easement. All 3,500 acres were transferred on paper to a development shell company. Money changed hands. Future plans were drawn. The HOA congratulated itself for securing community growth. I found out the way most people do, accidentally. A letter arrived addressed to new property occupant. It welcomed the recipient to a future residential community and referenced scheduled clearing dates. According to the letter, construction would begin soon, and any remaining personal property should be removed. That was the moment everything stopped feeling theoretical. A deeper investigation revealed the scope of the fraud. Recorded deeds filed without notice. Signatures that looked authentic at first glance. HOA meeting minutes that had been retroactively edited. The association had acted as if it owned something it never had the right to touch. What made it worse wasn't just the crime. It was the confidence. They believed the paperwork would intimidate me. That legal costs would scare me off. That one individual wouldn't have the resources or patience to fight a system designed to bury resistance under procedure. They were wrong. Instead of reacting publicly, I went quiet. Every document was copied. Every filing timestamp was reviewed. Every HOA board member's signature was cross-checked against known handwriting samples. County clerks were consulted discreetly. Title insurance loopholes were examined. Developer contracts were analyzed line by line. What emerged wasn't just fraud, it was negligence layered with arrogance. The HOA hadn't just overstepped. They had exposed themselves. By trying to steal land they never owned, they triggered clauses in their own bylaws. Emergency powers they invoked had conditions they didn't meet. Authority they claimed only applied to properties under HOA governance, which the farm never was. But the most important discovery came last. The HOA's master deed structure, combined with improperly recorded liens and cross-collateralized development loans, meant something dangerous. In trying to absorb land they didn't control, they had legally entangled every home in their association into a single fragile chain of liability. One break, and everything unraveled. They thought they had taken a farm from a quiet landowner. In reality, they had handed him the legal leverage to take everything they owned, one house at a time. As bulldozers sat idle and developers waited for final clearance, the HOA had no idea what was coming next. And that was exactly how it needed to be. Silence became my strongest weapon. While the HOA celebrated what they believed was a completed land acquisition, I continued moving quietly through records offices, legal databases, and archived filings that most people never bother to examine. The deeper I looked, the clearer it became that the sale of my farm wasn't an isolated act of corruption. It was the result of years of careless shortcuts, internal rule bending, and a belief that no one would ever challenge them. The HOA's authority ended at its boundary lines. That boundary was clearly defined in its original charter, a document filed decades earlier when the neighborhood was first developed. Every expansion since then had required unanimous consent from landowners and county approval. None of that existed for my farm. The so-called annexation documents were not only invalid, they were legally meaningless. But fraud has consequences that go far beyond one illegal sale. When the HOA filed forged deeds claiming ownership of my land, they unknowingly triggered provisions tied to their financial structure. The association had taken out large development loans using collective property value as leverage. Those loans were backed not by one property, but by the combined value of every home in the HOA. Normally, that system worked in their favor. This time, it didn't. By falsely asserting ownership over land they didn't control, the HOA corrupted the chain of title that supported those loans. Title insurers flagged inconsistencies. Lenders placed temporary holds. Developers started asking questions. The illusion of authority began to crack. At the same time, I uncovered something even more damaging. Several HOA board members had personally signed off on documents outside their legal capacity. Those signatures tied them individually to the fraud. It wasn't just an association problem anymore. It was a personal liability problem. Instead of filing a lawsuit immediately, I did something far more effective. I purchased debt. Through perfectly legal channels, I acquired portions of the HOA's outstanding obligations. Small at first. Then larger. Each purchase granted access to disclosures the HOA never expected an outsider to see. Those disclosures confirmed what the documents already suggested: the HOA was over-leveraged, disorganized, and exposed. One carefully timed filing later, the association was officially in technical default. That single status change opened doors most homeowners never realize exist. Default allowed creditors to enforce remedies. Remedies allowed liens. Liens attached not just to the HOA entity, but to the properties governed under its authority. Every home, every lot, every driveway suddenly sat under a legal shadow created by the HOA's own misconduct. And it was all lawful. County notices went out. Title flags appeared on individual properties. Refinancing stalled. Home sales froze. Panic began spreading quietly, long before anyone publicly acknowledged it. The HOA scrambled internally, trying to reverse actions that could not be undone. Emergency meetings were held. Lawyers were retained. Developers pulled out, unwilling to touch a project tainted by title fraud. Meanwhile, I completed the final piece of the puzzle. Using the same county recording system the HOA had abused, I filed corrective claims. These filings didn't accuse or threaten. They simply stated facts, backed by evidence, and cited the HOA's own bylaws against them. Each filing was airtight, reviewed, and approved. Then came enforcement. Properties within the HOA began appearing in public records under notice of action. Not foreclosure, yet. Just enough to apply pressure. Enough to remind every homeowner that their biggest asset was now entangled in a mess created by people they trusted. And there was nothing illegal about it. The HOA had created the structure. They had signed the documents. They had crossed the line first. All I had done was follow the path they laid out. As the farm sale unraveled and the fraudulent deed faced imminent reversal, the damage spread outward. Investors walked away. Insurance providers refused coverage. The HOA's financial safety net vanished almost overnight. The neighborhood that once tried to absorb my land now found itself being slowly, legally absorbed by consequences. But the story wasn't finished. Because the final step wasn't about pressure or leverage. It was about resolution. And the law offered only one clean way out. The same system the HOA used to take my farm could now be used to take everything they governed, fairly, transparently, and permanently. The question was no longer whether the HOA would lose. It was how much would be left when it was over. By the time the legal process reached its final phase, the outcome was no longer a matter of speculation. It was inevitable. The HOA's attempt to quietly erase its fraud had failed, and every move they made afterward only tightened the net they had created for themselves. The farm's sale was officially voided, the forged deeds were struck from county records, and the land returned cleanly to its rightful ownership. But that was only the beginning. The unraveling of the HOA exposed years of misconduct that went far beyond one illegal transaction. Financial audits revealed misused funds, unauthorized contracts, and deliberate misrepresentation to lenders. The association's legal defense collapsed under the weight of its own documentation. Every signature, every filing, every false claim of authority became evidence, not just of incompetence, but of systemic abuse. As creditors enforced their rights, the structure the HOA depended on finally turned against it. Liens moved from abstract legal concepts to active enforcement tools. Properties within the association became assets tied directly to the HOA's liabilities. Homeowners who had trusted the board found themselves legally connected to decisions they never approved and actions they never knew existed. The process was slow, deliberate, and unrelenting. Homes entered receivership one by one. Some were sold to satisfy outstanding obligations. Others were transferred under court supervision to neutral parties. Each transaction followed the law precisely, leaving no room for reversal. There was no dramatic confrontation, no emotional appeals that could undo what had been signed and filed years earlier. The neighborhood changed rapidly. For sale, signs replaced HOA banners. Construction plans were cancelled. Amenities once advertised as luxury perks fell into neglect. What had been marketed as a perfectly controlled community became a case study in what happens when authority is abused without accountability. Meanwhile, the farm remained untouched. Fields continued to grow. The land stayed quiet. What had once been viewed as prime development property was now legally protected in ways the HOA could never challenge again. Conservation easements were filed. Ownership was reinforced. Future attempts at annexation were permanently blocked. The irony was impossible to ignore. The HOA had tried to expand by force, assuming the law could be bent to their will. Instead, the law had expanded outward, consuming everything they governed. Their own bylaws, financial structures, and shortcuts had become the mechanism of their collapse. By the time the final filings were completed, the HOA no longer existed as a governing entity. Its charter was dissolved. Its authority revoked. Its name remained only in archived records and cautionary legal references. The homes remained, but the association that once controlled them was gone. The developers who once waited eagerly for access to the farm moved on. The lenders rewrote their policies. Title offices updated their procedures. And quietly, without fanfare, the system corrected itself. What began as an illegal land grab ended as a total reversal of power. Not through threats. Not through shortcuts. But through patience, documentation, and the careful use of the very rules meant to protect property rights. The farm stood exactly where it always had, open, unbroken, and finally secure. And the neighborhood that tried to take it became a reminder of a simple truth. When authority is built on fraud, it doesn't need to be attacked. It only needs to be followed to its logical end.